You could have called the police. You could have let the victim know that something may happen and he could move the safe. And I'm going to tell you, I heard from the victim here. I don't believe he wants to destroy you. I don't believe he wants to see you go to prison for the rest of your life or for the maximum penalty. I believe he fully wants you to rebuild yourself, change your course, and be a better person and help the community, be a counselor, help others, other information.
In March of 2024, I went into my pole barn and the door was unlocked, which I thought was strange. After going inside, I look over and a lot of my property has been moved around. And in the corner of my barn, I saw that my mother and my family's safe has been dug up and stolen. After my family passed away, I had major issues with the bank getting access to my safety deposit boxes. So I just decided to buy a safe, put all the estate items into it, and bury it where no one knew where it was. Inside of the safe was my 9mm handgun, my grandmother's multi-generational diamond ring, my great-grandfather's watch, and gold and silver coins, and multiple other family property that is irreplaceable. The only people who knew where that safe was located was my wife, my mother, and my father-in-law who helped bury it. The thieves were able to get into my pole barn without any forced entry, and the only person that had a key prior other than my family was my former contractor who was friends with Heather. The thieves or Heather somehow knew right where that safe was located in the back corner of my pole barn, buried underneath a foot of dirt where I had heavy machinery and deer stands on top of it. It was located where no one would ever know where it was, and it hadn't been touched in years. There's no possible way any one person could have lifted that safe by themselves, and I know Heather had help in stealing this safe. And I would gladly agree to no sentence if she would just tell me who the main people are responsible. My mother is a widowed elder woman, along with myself, my wife, and my 2 young children, age 5 and 2. Knowing that Heather and other thieves had came onto our property and stolen a firearm, along with my family's legacy, makes me extremely anxious, afraid, and we do not feel safe in our own home. I've had to spend significant amount of money to install additional security measures so our family can still continue to live at this residence, but in fear. Since the initial theft, we have been targeted again and another shed broken into.
Wait, this wasn't just somebody stealing a safe. Bro says it was buried under a foot of dirt with heavy equipment sitting on top like it was a movie vault. Inside, family heirlooms you literally cannot replace. Inside then he says only a handful of people even knew it existed. The judge sits completely still, eyes locked in, like he's already wondering who tipped him off. But then another name enters the story.
With no other neighbors broken into, and the person on the footage has a very high resemblance to Heather's boyfriend. Law enforcement is very aware of the other parties involved, and these people have no respect for law-abiding citizens. The dollar amount of this theft is also extremely high, but the monetary amount doesn't really matter to me as much as my family heirlooms, as I would give anything to have my grandmother's multi-generational diamond ring back, because I was going to give it to my son to give to his future wife someday. The amount of this theft, as you stated, qualifies as a Class F felony. If she would just tell us who the main people are responsible for this theft is, I would gladly agree to time served. But with the amount of theft, no cooperation on naming the others involved, no recovery of the firearm, and never being able to get my family legacy items back, I think the plea is light in terms of sentencing if she is going to take full responsibility for this. I thank you for your time.
Thank you.
This is a joint agreement for 18 months initial confinement, 42 months extended supervision, and costs. And she's the one who happened to leave behind evidence. A cigarette butt at the crime scene where she told law enforcement she'd never been, the presence of her phone in the same area where she said she'd never been to, suspicious messages between her and the only other man who's not in Mr. Fry's family who knew where the safe was buried. And then some of the stolen property started to be recovered to people that can be connected through her, 7 degrees to Kevin Bacon style, through phone logs. Dakota Barf to Justin Pfaff to Heather Honeycutt. Law enforcement obviously has strong suspicions about certain people connected to Honeycutt who have substantially more criminal history than her, as being the main people involved in planning and executing the heist, as well as the contractor who knew where it was buried. We've talked about that at length when we talked about previously at the plea hearing and why it's in the public interest for this a plea agreement to be.
Nah, this gets even crazier. The victim says he'd actually accept less punishment if she'd just tell everyone who really planned the heist. Then the prosecutor starts connecting cigarette DNA, phone data, suspicious messages, like a detective board in a crime show. The judge slowly nods while listening. But wait, prosecutors say the real masterminds might still be out there. Yeah, this isn't as simple as it looked.
The reason there's only enough evidence to convict her versus them is likely because of their greater experience and skill at avoiding incriminating themselves. Basic things like not talking to the police, not keeping their cell phones on their persons when they're committing crimes, not leaving behind physical evidence. This is the primary reason for the joint agreement. This is clearly not one of the main people primarily responsible for planning, thinking up, and executing this heist. If it was, she would have posted bond long ago, as her bond that she's being held on cash for is a fraction of what this property was worth. Instead, the stolen property has been showing up in the hands of other people who are either more responsible or are friends of people more responsible. That being said, given the nature of the burglary, literally a safe heist of possibly the largest amount of valued property stolen in the history of our county, probation would unduly depreciate the seriousness of the offense.
While she has been in custody awaiting this day, there's been a limited amount of services that she could have received in the jail, but the ones that were available, she took full advantage of. And I think you can see that from the letters that were included in the sentencing memorandum. Thou shalt not steal. It goes back to the 10 Commandments. That is how ancient this offense is. And the legislature has seen fit to classify this offense as a misdemeanor. What makes this such a serious offense, what makes it a Class F felony, is the value of what was taken. Not necessarily that any aggravating factor in terms of how the theft was carried out or what was done with the property or to who. It simply comes down to dollars. So I ask you to keep that piece of it in perspective. No one was physically harmed. No one was threatened with harm. There was no violence alleged by anybody. No threat of violence alleged by anybody. Is that she is not a danger.
Now, the prosecutor basically says Heather wasn't the mastermind. She just left behind the evidence. Oof. Then the defense jumps in like, hold on, nobody got hurt. I mean, technically true, but we're talking about somebody's entire family legacy disappearing. The judge leans back, hands folded, giving that expression that says, you're gonna need something stronger than that. And the defense isn't done yet.
To the public. Heather's mother and her daughter, Candace, wrote to you, Judge, and I'm just as miffed as they are that Heather wanted to plead. This case to me is one that should have been tried. True character is how you act when the chips are down. The chips have never been this down for Heather. We've done our best to tell you her life story in the sentencing memorandum, and there have been some downs. There have been some downs, but the chips have never been this down, Judge. And so I want to draw your attention to page 14 of the sentencing memo, who, as far as I can tell, was a perfect stranger to Heather. And I want to quote things that Crystal had to say about Heather when she met her in the jail. It was probably Crystal's low point in her life. And what she said about Heather was, she reminded me that I still had value and purpose. When I felt I was falling apart, she was there for me. But what I hope you see from the sentencing memorandum is that what Heather has done with her time waiting for this day is to try to build people up. I ask you to adopt the joint recommendation.
I want to start by saying
Plot twist. The defense starts reading letters from people Heather helped while sitting in jail. Chuckle didn't see that coming. They describe her encouraging broken people, lifting others up, becoming somebody completely different behind bars. The judge's face softens just a little, but he's still impossible to read. Is any of this actually changing his mind, or is something much heavier coming?
that I want to take accountability for the wrong choices I've made that have brought me here before you today. To the victims, I truly and deeply apologize to you and your family. Also to the community and to my family. I know my actions have affected them as well. Before being incarcerated, I was headed down a destructive path. I knew I needed a change. I sat and prayed, asked for a way to help me change this path I was going down. I never expected it to be going to jail, nor did I want it to be that kind of circumstance. But it was. I needed a wake-up call, and I definitely got one. This last year has been one of the hardest and most life-changing lessons I've had to go through. While being in here, I lost everything. My home, my family was divided. I was abandoned by someone I love. My oldest daughter had to take responsibility of taking care of my youngest daughter while taking care of her own child. I stood in front of the mirror and I realized I had to face myself. I had to change myself because this is not who I was or who I ever wanted to become. Remembering what my family taught me is that the greatest strength you can find to lead you on the right path is that anything is possible through Jesus Christ who strengthens you. This last year has truly changed who I am and who I want to be. It's also opened my heart to what God has called me to do. While being in here, I've attended Bible studies and groups that I'm very thankful for. They helped in growing my faith and my mental and emotional strength. When I said that God opened my heart to what He's called me to do, I say this because also while I've been in here, I've met a lot of different women going through their own battles as well. And I realized that God gave me a gift of encouraging others through my own testimony. Also, while being in here, COs have pulled me aside to talk to other females to help. All right, when I am able to get back into the community, I want to be able to help others. I've already connected with a church and groups. I would like to go to college to become a counselor. I believe that my testimony of what I've been through can help others. As it says in Ezekiel 36:26, and I will give you a new heart, and I will put a new spirit in you. I will take out your stony, stubborn heart and give you a tender, responsive heart. God cleansed me this past year so that today I can say thank you and look at this year as a discipline that turned into a blessing.
All right, now Heather finally speaks. She owns her mistakes, says jail became the wake-up call she never expected, talks about losing everything. Then she starts talking about faith, helping other inmates, even wanting to become a counselor. Side of the courtroom gets really quiet. The judge doesn't interrupt once, just watches her carefully. But wait, his response is where this case takes another turn.
Thank you, Your Honor.
How do I say this? You have been through a lot in your life. As much trauma as one can possibly have in your childhood. But your life wasn't easy. I know you credit Justin for being a person to help you move away from your heroin addiction, but he still wasn't good for you.
No.
He still continued to bring you down the wrong path, and forefront became methamphetamine and other crimes, other things. You have to change your habits. You have to change the people you associate with, and you have to change yourself. I really want to see you as a counselor, Ms. Honeycutt. You are a very encouraging person to others in despair. You're able to listen to them, provide them guidance, while you are yourself facing the same thing, or worse. It's a lot of money. Over $100,000, perhaps more, maybe up to $200,000. I don't know. I haven't had the restitution hearing yet. But it's not about that dollar amount. The victim and his family have lost so much more than money. You can always make more money, earn more money, do more things to get money. You can never have money replace security, sanctity, heirlooms, a ring that was passed down from generation to generation. I can't say with any amount of anything that the second burglary or attempted burglary at the victim's property is in any way related to this. You're in custody. You were not involved in any of that. Sometimes it's been shown in our cases over and over again that once you're victimized, sometimes they get hit again by others or by the same people. And that continues to destroy the victim's sanctity. I mean, if you can't bury a safe in the ground, far under the ground, and put heavy machinery over it and other heavy things to protect it, other than a safe deposit box, and some people don't trust banks, where are you going to put it? Because if people find it and they are able to get it there, they're able to get it anywhere. And you were a part of that, Miss Honeycutt.
The judge starts by acknowledging everything she's been through. And for a second you're thinking, maybe this is going somewhere good. Then, boom, he reminds everyone this wasn't just stolen property. It was generations of memories, safety, trust, all ripped away. His voice gets heavier, and you can see everyone listening differently now. But he's not finished talking about her role in all this.
Whatever role you played, you were a part of that. A part of destroying the victim's sanctity. And both parties, both counsel are correct in the fact that I must first consider probation. I fully believe, Ms. Honeycutt, you were a minor role in this burglary, in this theft. But you played a role. You had other actions and conduct that you could have done to prevent this. You could have called the police. You could have let the victim know that something may happen and he could move the safe. And I'm going to tell you, I heard from the victim here. I don't believe he wants to destroy you. I don't believe he wants to see you go to prison for the rest of your life or for the maximum penalty. I believe he fully wants you to rebuild yourself, change your course, and be a better person and help the community, be a counselor, help others, other information. Because the unknown is what worries us the most. Or something like that is the quote. Because you were not the sole perpetrator. You were not the sole criminal involved in this incident. There were others. 1, 2, 3, how many? No one knows but you and maybe your counsel. You are not falling on the sword, Miss Honeycutt. You do not have to take that upon your shoulders, Miss Honeycutt. I don't even believe this was your idea, Miss Honeycutt. You do not need to protect others who have failed you, who have seen you sitting in that chair time and time again, knowing that you could go to prison, who did not care one bit about you taking the blame wholeheartedly. This is a case where I understand the objective of the agreement. You are a small party, a little potato in the big crock pot of pot roast. And I have to look at treatment options and the ability to avail yourself of the programs in prison, because I can't guarantee you're going to do that when you are released.
Now the judge gets personal. He tells Heather he doesn't believe she planned this whole thing. Wait, what? Then he says she's protecting people who wouldn't think twice about letting her take the fall. Bro, that's brutal. The judge leans forward, almost pleading with her to stop covering for them. So you can feel the entire courtroom waiting for one decision. What happens next?
And I can't order that as an extended supervision condition. So what I'm going to do is I'm sentencing you to 2 years of initial confinement. I'm giving you a step up. It seems like a harsher sentence with 6 more months to have to sit, but you may not have to sit that if you engage in the program. I want to see you engage in that program, Miss Honeycutt. You are 40 years old. If you don't take control right now, it will take control of you. Time after time after time. So 2 years of initial confinement, followed by 3.5 years of extended supervision, $518 in fines and fees. We need to schedule a restitution hearing. I am also ordering that you cooperate with law enforcement regarding potential of others involved and cooperate by providing information if you have it or know of it as it relates to the heirlooms, the firearm, the ring, the other heirloom items that were mentioned. I can't order you to disclose, but I can order you to cooperate. And I'm going to tell you, Ms. Honeycutt, you have to look out for you, number one.
Here comes a moment everybody's been waiting for: sentencing. But the judge throws in something unexpected. He says prison programs could actually help rebuild her life, then orders her to cooperate in recovering the stolen heirlooms and firearm. The judge's expression stays firm, like this is her last real chance. But hold on, her lawyer immediately raises a huge legal problem.
You are number one. Your kids are number two.
In addition to that, the condition on cooperating, can we revisit that? I've never seen or heard of that. I don't even know if it's a
We've
lawful.
done it multiple times here.
All right, so can I ask some questions about it then?
Yes.
It's a significant condition because if she doesn't cooperate, then she could get revoked, right? So I want to make sure that I understand what that can.
I can't force her to say anything.
Then what is, then so Heather understands and we make it clear, what does it mean?
Cooperate means if they say, hey, Miss Honeycutt, let's have a talk. There's a talk.
Her obligation under this condition is to, if law enforcement asks to meet with her, she has to take the meeting. She has to be there in the meeting, but she can plead the fifth and not provide information.
Right. That's why I specifically said I am ordering her to cooperate with law enforcement concerning if they want to talk about those things. I can't force her to disclose. Don't know, it's perplexing because this has been ordered multiple times and asked for by the state multiple times in multiple cases, at least up north.
I'm sure it has. I've never encountered it before, and I think it's a fair question that she understands because the consequences of not cooperating.
My job isn't to inform her of her rights. That's your job.
Yeah, I understand, but
my job is to look at the victims and make.
Wait, the defense attorney hits the brakes fast. He's basically saying, Judge, if she doesn't cooperate, could she get violated? Now we're talking constitutional rights instead of burglary. The judge calmly explains his order, while the lawyer keeps pushing back. Chuckle, you can practically watch this turn into a courtroom debate instead of a sentencing hearing. And the ending? It's surprisingly awkward.
A condition, and you tell her what is within her constitutional rights.
Unfortunately, I don't run the Department of Corrections. I see them make wacky decisions and interpretations of court conditions all the time. And so this one concerns me. We've made a record of it. You've said that she can exercise her constitutional rights. And if this ever becomes an issue in the future, it'll be in the JOC, it sounds like.
Never had to do that before. An attorney has never questioned that because they usually counsel their client and say, you have the right to, your Fifth Amendment right to remain silent.
Well, I guess I'm different.
The judge stands by his order. The defense still isn't convinced, and neither one is backing down. It's one of those rare moments where both lawyers leave their fingerprints on the record before walking away. Sometimes the final argument isn't about guilt. It's about what happens after court. If you enjoy courtroom moments that keep getting wilder, like Subscribe to Case File USA, and I'll see you in the next case.